Good evening and welcome to the Planning Board meeting for Monday, February 12th, 2024. It's approximately 6:03 and I'm calling the meeting to order. Before we begin our meeting, there will be one general period of public comment tonight during oral communications. Persons speaking during the general public comment period may provide the Planning Commission oral communications on any matter concerning city business. Members of the public may comment in person or by telephone during the general public hearing public comment period. If you would like to participate in the public comment period by making an in-person comment, please present the completed speaker card to the planning staff. If you would like to participate in the public comment period by telephone, please call 818-238-3335. We will announce when the phone lines are open. Will everyone please rise for the invocation?
It's all very simple. The rules to follow. Love each other like you want to be loved. House the homeless, clothe the naked, feed the hungry. That's about it.
Please join me in saluting our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all. Madam Clerk, could we have the roll call?
Chair Rosati,
Here.
Vice Chair Wick,
Present.
Commissioner Monaco,
Present.
and Commissioner Makatumian,
Present.
and Commissioner Elric is not here.
Thank you. Do we have any announcements from staff?
No, sir, we do not have any announcements tonight.
Thank you. There are two public hearings on tonight's agenda. Item number one, now is the time and place for the public hearing for project number 23005367, an appeal of the director's decision that the emergency removal of the three public trees located at 113 North Niagara Street, 434 North Niagara Street, and 400 South Keystone Street is statutorily exempt from California Environmental Quality Act pursuant to the California Code of Regulations, Title 14, Section 15269C pertaining to emergency projects. Under Burbank Municipal Code Section 9-3-0108, this hearing is an independent reexamination of the environmental or procedural issue raised by the appellant in the written notice of appeal, and the appellant has the burden of proof to show through substantial evidence that the original decision was improper at the end of the hearing. The planning board will deliberate and take one of the following actions. Number one, uphold the original decision. Two, reverse the original decision. Three, remand the decision to the director for reconsideration. Please note that because Mr. Ramirez, the city planner, issued the public notice of environmental decision on appeal under this item, the city planner will recuse himself from serving as the secretary to the Planning Commission on this item. Mr. Plumbeck, the planning manager, will act as the secretary to the Planning Commission for this item. Before we begin, do any Planning Commission members have any legal, financial, or other conflict of interest relating to this hearing?
No.
No.
No. Have any Planning Commission members had any communications, including written, oral, with any persons about this project?
No.
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 I'm just going to say and disclose that I received 4 phone calls regarding this. And my advice to the people that called me was, you'll hear everything that I have to say tonight. So I just again, they were just random people from the public that, that wanted to talk to me about this topic. Mr. Plumbeck, have the notices required by law been given?
Yes, they have.
And are there any written communications on this matter?
None beyond what's in your packet before you tonight.
Will the representative of the Community Development Department please introduce yourself and summarize the matter for us? You will have a maximum time of 15 minutes for your presentation.
Hi, good evening. May I have the presentation, please? Good evening, Chair, Commissioners, members of the public. My name is Amanda Landry, Principal Planner with CDD Planning. For your consideration tonight is an appeal of the Community Development Director's decision that the emergency removal of 3 public trees is statutorily exempt from the California Environmental Quality Act, or CEQA. Title IX, Chapter 3, Article 1 of the Burbank Municipal Code provides guidelines for the study of proposed activities within the city of Burbank and the effect that such activities would have on the environment in accordance with the requirements of CEQA. The article further establishes departmental responsibilities, the Community Development Department Director's responsibilities, notification requirements, and appeal procedures. Within this article, the city also officially incorporates by reference the state CEQA guidelines. And it also requires that the notice of the director's decision of whether to prepare an EIR, negative declaration, or declare a project exempt be posted at the Planning Division counter and be dated. And these notices are called Public Notice of Environmental Decision, or PNODE. On October 10th, 2023, the director posted a PNODE that the emergency removal of the 3 subject trees was statutorily exempt from CEQA pursuant to the CEQA guidelines pertaining to emergency projects. Based on information available and in consideration of recent experiences responding to the catastrophic failures of similar trees during wind and rain events, particularly those in February of 2023, the director determined that the threat to public health, safety, and welfare was such that the use of this statutory exemption was warranted, appropriate, and necessary to facilitate the immediate removal of these trees. The subject trees were subsequently removed between October 11th and 13th, 2023. This slide shows images of the subject trees prior to the removal. The poor conditions of the trees, including significant leans, uneven branch structures, loss of canopy, and major limb damage are readily apparent in these photos. After the PNODE was filed, the appellant submitted an appeal with the following written contentions. The city had engaged in piecemealing and that the emergency removal of the 3 trees is part of a larger project subject to CEQA. 2, that the city erred in granting an emergency exemption from CEQA. And 3, that unusual circumstances prevent the city from exempting the project from CEQA. Under the BMC, this appeal hearing is limited to considerations of the environmental or procedural issues raised by the appellant in the written notice of appeal, so the 3 things I just mentioned. So this slide and the following 2 slides will address the contentions made by the appellants in the written notice of appeal about the environmental or procedural issues they believed occurred. Issue number 1 was that the city engaged in piecemealing and that the emergency removal of the 3 trees is part of a larger project subject to CEQA, specifically the removal of an additional 119 trees previously analyzed by the city. The city's response to that contention is that the city is considering a separate tree removal project. However, the piecemealing exclusion does not apply to this situation, as the 3 trees pose an immediate risk to the neighborhood and the removal was separate from ongoing planning activities. With the likelihood of unpredictable future wind and rain events occurring, the city could not risk waiting 6 to 12 months for another environmental review to be completed, as the tree's catastrophic failures would pose a significant risk to the public health, safety, and welfare. This decision is supported in the CEQA guidelines, which, although excludes long-term projects, this also specifically states that the exclusion does not apply if the anticipated period of time to conduct an environmental review would create a risk to public health, safety, or welfare, or 2, if the activities, such as fire or catastrophic risk mitigation, are proposed for existing facilities such as trees in response to an emergency at a similar existing facility such as at other trees. In this case, the anticipated period to conduct an environmental review would be approximately 6 to 12 months, And given that the city had an arborist report indicating that the trees pose an immediate risk to the neighborhood, and the likelihood of unpredictable future wind and rain events occurring, the city could not risk, again, waiting 6 to 12 months for the review to be completed, as the tree's catastrophic failure would pose a significant risk to public health, safety, and welfare. Contention number two posed by the appellant was that the city erred in granting emergency exemption from CEQA because the conditions of the trees did not constitute an emergency. The city's response to this condition is that the BMC states the original decision is presumed to be correct, and the burden of proof shall be on the appellant to establish otherwise. The appellant has not submitted any evidence that the trees were healthy or were not in immediate danger to the neighboring area. The appellant submitted information and declarations from arborists who opined on their belief about the intent and general strategy for the evaluating of generally city trees and the condition of the 3 subject trees. These reports were known to staff prior to the issuance of the P-Node and are not new information. These experts did not personally see or evaluate the 3 subject trees or have any knowledge about local conditions. Further, the expert witnesses opined on a different project unrelated to the 3 tree removals. As noted in the city's arborist report, and clearly recognizable in the photos shown previously, the poor condition of the 3 trees posed a significant threat to the public health, safety, and welfare, and immediate action to remove these trees was necessary to prevent or mitigate the loss of or damage to life, health, property, or essential public services. Issue number 3, posed by the appellant, was that unusual circumstances prevented the city from using a categorical exemption from CEQA, and there is a reasonable possibility that the activity will have a significant effect on the environment. The city's response to this contention is that the city did not use a categorical exemption from CEQA. The city used a statutory exemption related to emergency projects. So therefore, this argument is irrelevant and does not apply. The consideration of this appeal is exempt from environmental review under the common sense exemption under CEQA, wherein the project in question, which is the appeal, has no potential for causing a significant effect on the environment. And then furthermore, this consideration of an appeal is not considered a project subject to the requirements of CEQA. Pursuant to the Burbank Municipal Code, the Planning Commission may uphold or reverse the director's environmental decision or remand the decision back to the director for reconsideration if substantial evidence of procedural or significant new environmental issues are presented. Even if reversing the decision, the Planning Commission is not authorized to make a new decision. So therefore, the appeal, again, is exempt from CEQA. As the appellant has not provided any new substantial evidence of procedural errors or significant new environmental issues that would necessitate the reversal of the director's decision or serve as cause for the director's decision to be remanded for reconsideration or reversed, the P-Node was issued appropriately. In addition, the trees have been removed and the issue is moot. Therefore, staff recommends that the Planning Commission adopt the attached resolution to the staff report, denying the appeal and upholding the director's decision that the emergency removal of the 3 public trees located at 113 North Niagara Street, 434 North Niagara Street, and 400 South Keystone Street is statutorily exempt from CEQA pursuant to CEQA Guidelines Section 15269C pertaining to emergency projects. And this concludes my presentation. Thank you.
Thank you. I will now invite the applicant, the appellant, or their representative to address the Planning Commission. You will have a maximum time of 15 minutes to make your presentation.
Okay, great. Let me just get settled here. And Madam Clerk, are you going to put up the PowerPoint presentation? Oh,
I have the presentation. Can you please show the presentation on the screen, please?
okay, this is the clicker?
Yes.
All right, let me just test real quick. Where am I pointing this at? Oh, this computer. Aha, okay. Okay, I'm ready to proceed. Good evening, my name is Jamie Hall. I'm a land use and environmental attorney with Channel Law Group. and I'm here representing the appellant, Guardians of the Pines. I just want to first acknowledge the fact that the 3 trees in question have been removed. The city should consider revising its ordinance such that the activity is stayed until an appeal can be heard, such as the city of Los Angeles. It's not often I'm recommending that people looked at the city of Los Angeles for lead, but this is clearly a big gaping hole in your appeal process. The Public Resources Code provides a right to appeal any environmental determination to the elected decision-making body. The city knew that this appeal had been filed and nonetheless went and removed the trees despite the fact that without having the appeal heard. So I just would like for you to consider and think about amendment of your ordinance. Number one, I just want to give a little bit of fundamentals of CEQA here because it's really important as you evaluate this appeal to understand what CEQA is all about. So CEQA requires an environmental impact report whenever a public agency proposes to approve a project which may have a significant effect on the environment. Oh, and actually, before I even go forward, I want to tell you that the reason why we're here today, despite the fact that the trees have already been removed, is that the city wants to continue to do this. On Thursday, there was a proposal to remove 8 more Aleppo pines. We had to go back to the court. A temporary restraining order was issued on Friday, preventing the city from removing the 8 trees in question. We expect the city to continue to engage in this behavior, and we thought this would be a good opportunity to educate the Planning Commission about this particular project and about what the law requires. A separate issue here, an EIR fulfills CEQA's objectives by requiring agencies to identify the significant effects on the environment, to identify alternatives to a project, and to indicate the manner in which those significant effects can be mitigated or avoided. How is a project defined under CEQA? This is super important for you to understand. The project is the whole of the action. The entirety of the project. You can't break it up into multiple pieces. That's what's called piecemealing, and it's absolutely prohibited under CEQA. Here's a case, Berkeley, Keep Jets Over the Bay, a famous case talking about this. It says agencies cannot allow environmental consequences to become submerged by chopping a large project into many little ones, each with minimal potential impact on the environment, which cumulatively may have disastrous consequences. So you can't piecemeal. It's a fundamental rule of CEQA. When should environmental review occur? Another fundamental concept. Environmental review should be conducted before an approval is granted. And our Supreme Court has said, if post-approval environmental review were allowed, EIRs would likely become nothing more than post hoc rationalizations to support action already taken. Other fundamental concept, when does an approval occur? So the term approval refers to a public agency decision that commits the agency, that commits a city to a definite course of action in regard to a project. So, putting all these pieces together, environmental review must occur before project approval, and that's to identify significant effects, think about the alternatives, and consider mitigations to reduce the environmental impacts. And an emergency exemption, that's what we're here to talk about today. The emergency exemption applies when there's a sudden, unexpected occurrence involving a clear and imminent danger demanding immediate action to prevent or mitigate loss or damage to life, health, property, or essential public services. And this is an important thing. It's a statutory exemption from CEQA, and it's supposed to be limited to occurrences, not a condition. So it has to be a true, immediate emergency, not something that has been known about for many years. Now, the other thing I want you to understand, and notably, staff did not mention this at all, is the fact that litigation is currently pending against the city of Burbank on this topic. And on this topic, I want to emphasize that you're here to exercise your independent judgment. And the city attorney may be giving you advice. That doesn't mean that advice is correct, and it doesn't mean that you have to follow that advice. And on 2 separate instances, the LA County Superior Court, Judge Lofton, has ruled against the city. So I want you to think about that. So I want to go a little bit about the litigation against the city. So the case was filed. It was a petition for writ of mandate under CEQA. It was brought on October 9th, 2023. An application for a temporary restraining order was filed on October 10th, 2023. The judge did not rule on the TRO at that time. The city then proceeded to remove the 3 trees in question between October 11th to the 13th, but the court nevertheless conducted a further hearing on October 31st, and the court issued a preliminary injunction preventing the city from removing any further Aleppo pines as part of the project. Now, in doing so, the judge had to rule that my client was likely to succeed on the merits of this case, that the city had done no environmental review prior to committing to a definite course of action. And he also had to rule that my client had more irreparable harm than the city did. And he specifically ruled on the city's contention that the emergency exemption was applicable, and he said it was not, and we'll talk about that. Now, as I previously mentioned, on Friday we had to go back into court because the city tried to avoid the preliminary injunctions mandate and tried to remove 8 trees, which they wanted to do today, and the judge issued a further temporary restraining order preventing them from removing 8 trees. Here's screenshots. On the left is the preliminary injunction order. On the right is the temporary restraining order that was issued on Friday. What's the project in this case? This is super important. The project is the Aleppo Pine Tree Reforestation Project. The city has alternatively referred to this as the reforestation strategy of the Aleppo Pines. The euphemistic language is almost more than I can possibly bear. But the project involves the removal of 119 Aleppo pine trees within the public right-of-way in the city of Burbank. 58 of these trees are located on a single residential street in the city of Burbank known as Niagara Street. This is where that fundamental CEQA concept comes in. Remember, the project is the whole of the action, not just 3 trees, not just 8 trees, it's 119 trees. Here's a report commissioned by the city. 119 trees are specifically identified in the report. This was submitted to the court. So there's no question that the project at issue is 119 trees. What did the court say? Say the project was defined as. The court said, applying this law to the facts at hand, the city's reforestation strategy is the project subject to CEQA. Although the city may need to approve the removal of each individual Aleppo pine under CEQA, the project is the whole restoration strategy, and the city is required to comply with CEQA as to the whole restoration strategy, verbatim from the preliminary injunction order on October 31st. What did the court say about whether the city had approved the project? Quote, here the evidence showed the city made decisions to approve this reforestation strategy, which plans to remove and replant the Aleppo pines without undergoing any CEQA review. The plan specifies 119 specific pines to be removed over a multi-year period. Considering the specifics of the reforestation strategy and the circumstances surrounding it, the evidence shows that the city has committed itself to this reforestation strategy so as to effectively preclude any alternatives. Significantly, the city has already begun implementing this plan, as evidenced by the city's removal of the 3 identified Aleppo pines, because this is what we're here to talk about today. So the court specifically said the city had committed to a definite course of action. So, you have to consider this, and you can't ignore the fact of what the court has previously ruled. What did the court say about the timing of the required environmental review? Quote, an agency is required to comply with CEQA, an environmental review, before approving a project. Again, fundamental CEQA issue. What did the court say about the timing of the required environmental review? Quote, because petitioner offers evidence, petitioner being my client, Guardians of the Pines, that the city did not conduct a preliminary review to determine whether the reforestation strategy is subject to CEQA before implementing the strategy, and the city does not offer evidence to prove that it did conduct this preliminary review, the court finds that petitioner has shown a likelihood of success with respect to its causes of action for violation of CEQA. What did the court say about the emergency exemption claim? So the city made this exact claim before Judge Lofton in Alhambra Superior Court. And here's an Alhambra Courthouse, LA County Superior Court. And here's what he said, quote, here petitioner puts forward evidence that there is no sudden, unexpected occurrence that triggered the emergency exception because representatives have known about the condition of the trees since 2018. petitioner puts forward the declarations of the two arborists who both state that the scope of the city's arborist review was skewed to favor removals and there was little consideration of pruning or other mitigation options. And that's the declaration of Gordon Mann at paragraph 18. 8. These experts opine that failure was not imminent for any of these trees, including the 3 identified Aleppo pines. Here's an excerpt from the Gordon Mann Declaration. He says, quote, "The design and scope of the third-party independent assessment was heavily leveraged toward removals. The focus was around a very low tolerance for failure. There was no pruning mentioned on any of the trees to reduce the risk of branch failures. Pruning is the #1 mitigation for reducing branch failures. The focus on a very low acceptable risk is not consistent with every other tree in the city, or more city trees will be scheduled for removal." And then this is, well, what did the court say about the exemption? The court said the city has not put forth evidence of any sudden, unexpected occurrence involving an imminent danger regarding the remaining Aleppo pine trees. The city does not point to any imminent disaster that would have caused these trees to fall that create damage before the city would be able to conduct environmental review. I just want to back up for a second. The emergency exemption is for like true emergencies. And it's an exception to the rule. CEQA is our most important environmental review in California. It requires environmental review before an action happens so that you can think about the impacts, you can think about the alternatives, you consider the mitigation measures. And that's kind of the fundamental problem here. This is a project that involves 119 Aleppo trees. The city has admitted that it has done 0 environmental review for the project, and now it wants to piecemeal the project. And so that's really what we're juggling with today. What did the court say about the exemption? The court said petitioner has also shown this is not about petitioner has shown a likelihood of a success with respect to the emergency exemption asserted in the city's notice of exemption filed on October 10th, 2023. Because petitioner has put forward evidence that shows a likelihood of success as to whether the project qualified for an exemption, this shows that it was likely that the city was required to conduct an initial study to determine whether the project might have a significant effect on the environment. The city has not done so. As such, the court finds that petitioner has shown a likelihood of success on the merits. What did the court say about the balance of harms? The court finds that there will be irreparable harm without this injunction. If the city is permitted to continue removing and replacing these trees, there will be no adequate relief provided to petitioner. It went on to say, further, the declarations of the experts show that the replacement trees will not provide the same benefits as the Aleppo pines, and the replacement trees will take decades to mature. Further, the city has shown that without an injunction, it can and will remove the Aleppo pines, as evidenced by its removal of the 3 identified Aleppo pines following the TRO hearing. Now, response to the staff report, I've looked at the staff report. Here's what the city is essentially trying to do. They're trying to redefine the project. Notably, the city has completely removed the websites that they created for the reforestation strategy in an attempt to do this. But the court has already issued an injunction resolving this question. The court defined the project. The project's 119 trees that are proposed to be removed. And the 3 trees at issue are part of this project. The city cites case law saying 2 projects may undergo separate environmental review, i.e. piecemealing, when the projects have different proponents, serve different purposes, or can be implemented independently. These aren't 2 projects. It's 1 project. It's the reforestation strategy that the city previously committed to, and the court said that they had committed to. And further, there's not 2 different proponents, and they serve the same purpose. Overwhelming evidence supports this, including the arborist report that the city's relying on. Now, the city now says in its staff report that it's considering a proposed Aleppo pine tree removal and replacement project. But again, the court said that the city had already committed to the project. There were staff reports submitted to the Sustainability Committee, the Rec and Parks Committee, testimony given to the City Council, where the court said that that was enough to show that there had been a commitment to the definite course of action. And finally, the emergency exemption already was rebutted by the expert declarations of Gordon Mann and Carl Mellinger. So we would respectfully ask that you grant the appeal. Thank you.
Thank you. We will now open up the meeting to hear from any persons who wish to speak on this matter. Each person may address the planning board for a maximum time of 3 minutes. For members of the public who wish to comment in person, please present a completed speaker card to the planning division staff. If you wish to speak, for members of the public wish to speak by phone, the number is 818-238-3335. To address the planning board, callers will be placed in a queue until all in-person comments have been received. The phone lines are now open. Please bear with us, as it may take a few minutes to get the first few callers through. For callers, please remember to lower the volume on your TV or your computer and take your phone off speaker when delivering your comment. Madam Clerk, do we have any callers on the line tonight?
No callers on the line.
Okay, I'll just go through the in-person first. Mr. McKinnon?
You guys don't know me very well, but I'm James McKinnon, part of the Guardians of the Pine. I'm not really great at this, so bear with me. In court the other day, and in this thing here, we keep using photos of trees that fell not on our street. It's called fear-mongering. Stop putting photos to make people think trees fell on our street. All the photos were multiple pictures of the same tree to make it look like it was more than one tree falling on our street. The hurricane last week, no trees fell. The hurricane, whatever it was, whatever lady's name it was last year, nothing fell. It's going to rain for the rest of our lives. These trees have been around for 100 years and have not fallen through how many before you all were born and myself have not fallen. We got to stop with the fear tactics, use the correct photos. Even on your paperwork here, you guys don't even have the correct address next to the correct tree. We have 3 trees that have been cut down and will never be back again because of lies by the city, Marissa Garcia, third-party people that are hired by the city, Mike Del Campo. It's all crap. My truck was crushed by one of the trees in 2003. You would think I would be up here going, cut them all down. You know why it fell? Because of poor job from Mike Del Campo. He cut the shit out of the tree so it leaned like this, and yes, it's going to fall because of the maintenance 2 times in 15 years? 17 years. 2 times in 17 years, you guys have trimmed these trees. You guys came out a couple weeks ago because you have $750,000 to spend really quick because you now don't have it to remove the trees, so they start chopping down branches off trees and making trees now, guess what? Leanable. I wonder if that's a fact, or if that's probably purposely done. We just drove by the 7 trees that you guys want to cut down, and now they're cut down in a fashion where they're just going to fall easier. Somebody needs to do their job right. Marissa obviously can't. Her buddy Wilkie is gone, so we'll see what happens there. Mike Del Campo knew about these a long time ago. It's absolutely ridiculous that all of a sudden, 5 years later, now we got an emergency. He lost sleep over it. There's videos of it. He's got gray hair because of it. It was a great speech. It was almost an Oscar speech. It's bullcrap. Stop. Listen to this gentleman. We have. I can't talk anymore. Thank you,
Great,
guys.
thank you. Last name's Campbell. Come on up, sir.
Greetings. My name is Quanah Campbell, Comanche Nation Heritage. I'm here to appeal not only to the physical part of all of this, but the spiritual part. These trees are our elders, and we appreciate their presence because they protect us from the rain, the wind, and everything else. One particular tree that they want to remove is an Aleppo pine in front of my property on the opposite side of the street. Big tree has 3 different branches. The problem is when they remove that tree, there will be a vast wind tunnel that will come through and affect the other trees on the other side of the street. Because I watch the wind, and most of our wind comes from the east, and it comes from the south. Once in a while, we get a northwest wind that comes in. that's the dangerous wind. That's the wind that without this tree here, and without these other trees that are proposed, there will be a chain effect. And just ignoring the spiritual aspect of this, the practical part of it doesn't make sense. If you're going to replace the trees, for heaven's sakes, please replace them with a tree of the same size. Never mind the spirits that are going to be gone from the trees that are there. That's my belief. If it's not the city's belief, simply from a practical point of view, you have to replace them with trees of equal size, healthy trees. There's no plan for that. Up and down our street, they're putting these, sprigs in that are like, that big around. And they're going to take, 40 years before they even come close to what we have on the street. That's not going to protect the other trees. That's not going to protect our properties from wind damage and many different things. But I'd like your reconsideration to halt the project until the proper reviews are made. There's one tree on my neighbor's down the street. Johnny's tree, it's tilted way inwards. He's afraid that's going to fall on his neighbor's house. That might be a good candidate to remove. But these other trees, just because they're big and they're old, just being old doesn't mean that you need to be removed. So thank you for your time. I please pray for your consideration, and I pray for your blessing, okay?
Thank you. Mr. Ballmer?
Staff, I don't want my tree cut down. I have lived on my street for 75 years. And my tree is still there and doing fine. It's as straight up and down as you could make a tree. It's not dying. The other day, they came out to trim the trees. And I said, what are you going to do? He says, well, we're going to trim the dead stuff off the tree. So I didn't pay any more attention to it, and then I went out after they did it, and there's nothing dead on the ground. There's nothing dead. So they're lying. Why are they lying? This isn't even the city. It's Mariposa, I think. And then I tripped on the branch that fell down the next day, fell in the street. I couldn't walk for a few days. I twisted my ankle really bad, and my back hurts to this day. The guys drove by the next day. They went right by the branch that laid in the street, and I'm waving to them, come back. Our temperatures are going to go up without the trees. Everybody likes to walk on our street because it's so cool. The sidewalk is hotter than heck. Our electric bills will go up. Our prices, home prices, will be affected. And like he said, they are not supposed to be doing this stuff anyway.
Mrs. Ballmer?
Good evening. I'm Cheryl Ballmer. I live at 208 North Niagara Street. Number one, I don't know who took the pictures, but 400 South Keystone here, that's Niagara Street. They have, I don't know what, anyway, they don't have the pictures right, so you really can't go by these pictures. There are trees on our block that definitely need to be cut down. We were walking down the street the other day, and this one tree is, it's really leaning, and a car was parked. I wouldn't park my car there, but someone did. But if that tree went down, that car would be gone. But yet they cut down trees, other trees. To me, that would be, I'd get that tree out of there. And I'm not an arborist or anything, but if a tree is like this, you're going to cut it first. For some reason, Mrs. Garcia decided that these trees should come down. We got a letter, and I don't remember how many days that it was, but they were going to cut, without any notice, nothing, they're going to cut our trees down in a week or two. Where did that come from? You know, who decided that? And those trees, I mean, you need to go down that street. It's beautiful. And like my husband said, our tree is green. There's nothing wrong with our tree. Now, across the street where he grew up, he called the city because that tree had diseased. And they came out, and they took it down, and they put up a new tree. And that's what should happen. If the tree is diseased, of course take it down. But if it's not, what's the purpose? And then also at the end, Oak in Niagara, they planted, well, I think my husband has a picture of trees. All pine trees here at the corner, little trees. Not pine trees, I don't know what they are, but they don't fit in at all. And who gives the direction on, what tree to plant where? And I'm just asking you to think about it. If the trees don't need to be down, don't take them. That's our neighborhood. That's where we live. That's where I've lived for 55 years. And I love my street. It's a personal thing for all of us. I think the couple, James and them, bought their home
Your
on
time is up.
Niagara because they loved that place. And they paid a lot of money for their home. And then to live there 2 years and have the trees cut down, it doesn't make sense. Thank you.
Thank you, ma'am. Dane McKinnon?
It's Diane. Hello. I am the leader of the Guardians of the Pines. My name is Diane McKinnon. We're here to talk about 3 trees that came down months ago while the residents of Niagara Street were hauled back to court Friday because of 8 more trees slated to come down today. Luckily, the judge saw that the continued tactics of failure to give sufficient notice, along with the fact that these trees are in fact part of an original plan, has given us time to even just read the reports. The true issue here is the ongoing lack of transparency and communication from the city. You've been looking at these trees for 2 months, according to your statements in court, and only gave our lawyer, not the residents, less than 2 working days' notice. Shame on you. And if you're sitting here saying, not me, you're wrong. The city means everyone, all paid employees and elected officials to all councils and commissions. That's the responsibility you took on when you took your positions in the city. The fact that this project for the removal of 121 trees in one concentrated area was approved and funded without anyone, not even our city legal team, knowing or even looking to see if it violated any laws is a really upsetting and a huge concern to all residents. How did $750,000 get allocated to the removal of 121 trees in a concentrated area, and how did that get approved? How does our legal team not even have one CEQA certified lawyer on it to even check that? When it went to Parks and Rec, when I took it to Parks and Rec meeting in July 2023 with this plan, they didn't know what I was talking about. When I took it to the Sustainability Commission meeting the next day, they didn't know what I was talking about. When I took it to the City Council meeting the following week, they didn't know what I was talking about. How is this even possible? How is it really true that Marissa Garcia can spend over $1 million with taking down and then replanting all of these trees with taxpayers' dollars on an illegal project, and there's no checks or balances in any way whatsoever? One department head can make such a devastating change to the environment of our entire city without so much as a community meeting, and there are no legal checks or before approving a plan of this magnitude. And when I say community meeting, I don't mean the one that we had on November 1st, the day after court, where There is no back and forth, no questions answered, no listening to residents' concerns, no willingness to work together, and numerous police called to stand at the back of the room to intimidate and be rude to residents, because that is what happened when Marissa Garcia and Mike Del Campo hosted the residents of Niagara Street at the library the day after court, after you lost your injunction, after the judge said in court he wants to see us communicating and prevent this going to trial. From day one, we have asked simply for open dialogue, back and forth communication and transparency, and the most importantly, to be a part of the plan making, to come up with a staggered approach to the removals, to look back at all, I want you to look back at all the meetings
Ms.
in
McKinnon,
this room
Ms. McKinnon.
from July, and I want you to see what we have come
Ms.
to the
McKinnon.
table with. This is ridiculous.
Thank you. Last speaker card, Mr. Donahue. Do we have anyone on the phone? Okay.
Good evening, Commissioners. David Donahue. I have been present on many of these kind of conversations about the Aleppo pine trees. One, I will give a little bit of validation to the particular leads on this, is that the communication by, I believe, the city of Burbank was a little bit lax. I think it could have been better. I think they could have given out the notices a little bit more effectively. So to give time, to give people time, the time to form a response and to follow the process, to complain, to go to the commissions, to go to the various boards and to city council. The issue that I find a little bit of a concern with is the vilification of Marissa Garcia, the vilification of the city, which I think is unwarranted. I was at the Sustainability Commission where there were very high levels of emotion. I even said point of order to the chair and said that the person who also spoke tonight was actually out of order for identifying somebody and being very aggressive. So I understand why Marissa Garcia probably wanted police in that room. For the people that are here that they have advocated, they have a concern. For the people that have been listening to their rhetoric, I would say listen to it with a grain of salt. Continue the course, continue to argue, but be careful about the vilification that you use towards the city, because I have found many times where I am at a different opinion with the city and have engaged well. The responsibility to the commission and to the city to look at the responsibilities to protect the community is a big one. I applaud you for hearing this. I applaud staff for bringing it forward, and I applaud staff for not being intimidated. It is a tough decision to look outside of what the plan is. There's the applicant's attorney advocated that there's a plan. The plan is the broad plan, as I understood it here during the 15 minutes of his presentation. The plan is broad. It's not specific to the 3 or to the 8. Those are the ones that are at most at risk. As I have 2 doors away from me, probably a 100-foot pine tree, I'm not sure if it's Aleppo, we get nervous when the winds blow. And I have heard that personally from a resident on Niagara, in the area that is affected, that when it does rain and winds, he and his family sleep in the back. Why haven't you heard from him? I think the example is very clear why you haven't heard from somebody like that. Thank you very much for your time, and I respect the decisions you're going to make. Thank you.
Thank you.
You don't even live on our street.
Excuse me, let's be respectful. Everyone gets a chance to speak here. Everyone gets a chance to speak, whether for or against. I'm asking you to be respectful. That's all I'm asking. There's no reason to intimidate anyone. Be respectful. Any more persons from the audience wish to speak? Fill out a card, ma'am. Come on up. Yeah, we should have a card. But why don't you speak first and then just fill out the card, just for time's sake.
Thank you, everybody, for being here and for trying to fix the situation.
Your name is?
My name is Farah Sadi. I'm a homeowner and a resident of Burbank on Niagara Street. And my hope is that we can work together to not move forward with the removal of the 119 trees, but instead put forth other mitigation plans like pruning the trees. If there is a tree that's diseased, that's fine for that to be removed, but not to have a mass removal of 119 trees when there are plenty of those trees that are completely healthy. I myself have owned my home on Niagara Street for over 10 years now, didn't even receive a notification from the city about any removal of any trees. I found out on the Nextdoor app, thanks to neighbors who care, who posted, hey, did anybody get this letter? So not only did we not get a proper CEQA environmental review in a timely manner before the project started, but also many people did not get communication. I never got notification, and it was like very bizarre that I had to find out on an app like Nextdoor. So my hope is that we can work together, fix the situation, prune the trees, let's leave intact any healthy trees that we can. Thank you.
I appreciate it. Thank you.
Is there? I'll show you.
And then let's have the caller.
We have Jean on the call.
Good evening.
Thank you. Good evening, Chair Rosati and members of the Planning Commission. My name is Jean Schanberger. I'm a resident of the city of Burbank. I don't live on Niagara, but I'm calling in support of the appeal by the Guardians of the Trees and the work that their attorney has done in their litigation matter. I have some familiarity with this through my previous role on the Burbank Sustainable Commission, and I attended the community meeting at the Burbank Library at Buena Vista that was hosted by Parks and Rec staff with some of their consultants. The thing that troubles me the most is the absence of an urban forestry plan. These trees are obviously a significant specific concern, and some of them have come down, which is really unfortunate. But walking around the city, it seems like, everywhere trees are coming down. And I know the Sustainable Commission last summer had asked for that to be brought forward. I'm disappointed, taking at face value the statement from the appellant's attorney that the website the city had put up regarding the urban forestry plan is not currently active. I don't. If that's accurate, that's really disappointing, because that was a big piece of the communications promised from the city. So I'm just disappointed that the city as a whole has not been more forthcoming on their urban forestry plan and continued to take actions that, as many of the callers have indicated, are irreversible. Thank you for your consideration of this important topic tonight. Good night.
Thank you. Do you have any other callers?
No other callers.
Great. And now declare the public comment period closed. Would the representative of the Community Development Department like to make any further comments? You have a maximum time of 10 minutes.
Hi, yes, Chair. We do have a few responses to comments. The appellant and many of the speakers have brought up the larger issue of the city's reforestation strategy. That strategy is not the subject of the appeal tonight. The subject of the appeal tonight is the director's decision to issue a P-Node statutorily exempting the removal of just 3 of those trees under the emergency projects provisions of the CEQA statute. And it's very clearly established in the CEQA statute that the circumstances related to these trees is excluded from the overall project and piecemealing considerations. So again, the subject of tonight's appeal is only the P-Node for those 3 trees. And the commission can look at the issues raised by the appellant in their written appeal, and the decisions that the planning commission can choose to do tonight are to uphold the decision of the director, remand the decision of the director back to the director for consideration, or reverse it. The commission cannot make another decision. The commission cannot comment or give direction on the other project going on regarding the city's reforestation strategy. That is not part of this project. And then in addition, the BMC very clearly states that the director's decision is presumed correct unless there is substantive evidence provided by the appellant during this process that it was incorrect. And there has not been any new information provided by the appellant in their appeal or tonight that refutes or amends or supplements their actual appeal. So there's no additional information. All the information that was in the appeal the city had before the decision was made. And then in response to some of the questions or comments from the public, the pictures that were shown in the presentation were taken directly from Exhibit B, which is from the appellant's submittal. I apologize if there was a mislabel, but those are pictures from the applicant's submittal. My other notes, sorry. And again, I just want to re-emphasize again, because it was brought up by most of the speakers, that the concerns about the overall reforestation strategy that applies to over 100 trees is not what is for consideration tonight. It is simply just the emergency removal of the 3 trees that, as the city has established, and the city has established in the arborist report, were an imminent threat to the neighboring community. And due to the uncertainty of any wind or rain events or any kind of event, the uncertainty of the risk to the public was far too great for the city to just wait for 6 to 12 months for additional studies to be done. And that is why the director's decision to exempt that removal from CEQA was given. I think that covers the salient points from all the comments. Again, staff is available for questions from the commission.
Thank you. Does the appellant or their representative wish to make any further comments? You'll have a maximum time of 10 minutes.
Could you put back up the PowerPoint presentation for me? Sure thing. Thank you, sir.
Just give me one moment. Okay, please show the presentation. Thank you.
Okay, great. So this won't take too long here, but it may take me some clicks to get to the right place. Let's see here. I need some hold music, so it's more interesting. Does approval occur? Can an exemption be used? Litigation against the city. Okay. Guardians of the Pines. Blah. Here. Okay. So the first thing that we heard in rebuttal from the planning department is that these 3 trees are not part of the overall strategy. That was what you heard. But what did the court say? Remember, we've already litigated this. You're in a unique situation here where a Superior Court judge sitting in Alhambra Courthouse has fully looked at what the project is defined as, and he has issued an opinion. And so the city has to live with this reality. And this is what he said. Here, the evidence shows that the city made decisions to approve this reforestation strategy, which plans to remove and replant the Aleppo pines without undergoing any CEQA review. The plan specifies 119 specific Aleppo pines to be removed over a multi-year period. That's the larger plan that staff is talking about. Considering the specifics of the reforestation strategy and the circumstances surrounding it, the evidence shows that the city has committed itself to this reforestation strategy so as to effectively preclude any alternatives. This is the sentence that matters. Significantly, the city has already begun implementing this plan, as evidenced by the city's removal of the 3 identified Aleppo pines. So what is the court saying there? The court is saying that the 3 trees that we're talking about today are part of this plan. The city's escape hatch here, their whole strategy here, is to somehow redefine the project. And if they can redefine the project and then take away certain aspects of it, they can avoid this problem of piecemealing. And that's what they're trying to do. That's why they removed that page on their website talking about the project that identified all the 119 trees. They're trying to recast what they're doing, but they can't do it. A Superior Court judge has already said that the project consists of 119 trees, and these 3 trees are part of it. The other thing I want to point out here, the planner said that there was no evidence of, or that they had substantial evidence to support their emergency exemption. Get to the right place here. And again, the court has already opined on this too. You're in a unique situation. You can't just accept everything that staff is telling you because a Superior Court judge has reviewed all the evidence. There were multiple filings, briefs, declarations, 2 hearings, one on October 10th, another on October 31st, and thereafter a minute order was issued, a 10-page single-space minute order. And the judge said, with regard to the exemption, as such, petitioner has also shown a likelihood of success with respect to the emergency exemption asserted in the city's notice of exemption filed on October 10th, 2023. That's the one we're talking about today. Because petitioner has put forward evidence that shows a likelihood of success as to whether the project qualified for an exemption, this shows that it was likely that the city was required to conduct an initial study to determine whether the project may have a significant effect on the environment. The city has not done so. As such, the court finds that petitioner has shown a likelihood of success on the merits. These trees have already been removed. They can't be put back together. But remanding this back to the planning commission, to the planning director would send a message that you don't need to put the city in this perilous situation that where piecemealing continues to occur. Piecemealing cannot happen here. The project has been defined. It's 119 trees. Environmental review must occur before the project is approved, and it serves a good purpose. So we can talk about staggering potential removals, what the replacement species might look like, how big the canopy would be, what trees should be removed, whether or not there should be branches that are removed or root pruning that occurs. There are alternatives that need to be evaluated. But the city here seems to be, and this is not me just speculating, because I was just in court on Friday getting another TRO. So the city needs to be told, the planning department, the director of planning needs to be instructed through your remand. Now, I understand you have options and maybe granting the appeal isn't one of them, but remanding this back to the director saying, you need to think about this some more is also sending a message. It's sending a message that you don't want to see the city in court again over this. It's sending a message that you care about your urban canopy. It's sending a message that you believe in CEQA, you believe in its purposes, you believe in compliance with the law, and you care about your constituents. And so, with all due respect, we disagree with staff's assertion that certain trees can be taken out of the 119 and called something else, because you're just defying a judge when you do that. I don't have anything more to say. Thank you for your time. This is a passionate issue on all sides, and I trust you understand that. So thank you very much.
Thank you. Does the commission have any questions for staff or the appellant? Go ahead. Did you say yes? I'm sorry.
I'm not sure if I can ask this question. Are these 3 trees part of the larger 119 project?
Audience, I'm going to ask you again, unless you're at the public microphone, just to remain silent as we try to figure all this out. If you're talking, we can't figure this out because you're impeding what we're trying to think about. So I'm asking you just to remain quiet. Thank you.
Good evening, Senior Assistant City Attorney Jill Vanderbort. Good evening, Commissioners. First, all of those arguments, as the Senior Planner indicated, are beyond the scope of the appeal. But because they were so enthusiastically reiterated, I want to tell you that I think there was mischaracterization of the court's order on the initial temporary restraining order. Reading directly from it, the city puts forward evidence that following the court's denial of the temporary restraining order with respect to these 3 trees, the ones that are at issue in the P-Note appeal tonight, the city completed the removal of the 3 identified Aleppo pines. So the court acknowledged that. The court agrees that petitioner's request is moot as to petitioner, the guardian's request to halt the removal of the 3 identified Aleppo pines. So no, they were not part of the project. The city identified them and pursued their removal subject to this NOE.
Were the trees diseased?
I am not a certified arborist. They had been identified by a certified arborist, both internally and externally, as needing urgent removal based on the characteristics they saw on those trees.
Okay, that's all I have.
Any other questions for,
Yes, so when the public notice of environmental decision was posted, or I'm assuming the P-Note went out to residents also, or does that not get sent out to residents?
No, the P-Note pursuant to the Burbank Municipal Code must simply only be posted at the planning counter.
Okay, and did anyone comment on at the public counter regarding this P-Note?
The only communication we had was the appeal submitted by the appellant.
Okay, thank you.
Ms. Wick?
Just a quick question. Do we have the court's decision in our packet? I feel like it was somewhere, but
There is not a relevant on-point court decision. That was misleading. It does not matter what ruling the court may have made. They did not rule as to the procedural and substantive process in the P-Note, which is what you're being asked to consider tonight.
Got it.
The appellant, please. Staff had indicated that the pictures that were mislabeled came from you. Is that correct?
I'd have to look at the, it may be that I was attaching some other document, some city document. I'm not really sure. I have to look at that.
You're pretty passionate about that, though. In the beginning, you're pretty passionate about that. Now you're not sure?
No, I'm not. That was some other person who was indicating about the mislabeling and things. I don't think I talked about the pictures and the labeling of that.
Sure.
Yeah, I'm positive.
And why do you think these 3 trees, out of 119 trees, as you state, why do you think it was these 3 trees?
Well, I know why, because the city prepared a report. It's got like the RWR report or something like that. I think I had it on my PowerPoint presentation. And the arborist went through the 119 and he labeled them with different categories. These 3 were marked urgent, and then there were others that were marked 4, 3, 2, and 1, and they had different addresses. So this was a report that the city commissioned. So that's why these 3 trees were chosen.
And do you have a report that would say different?
The declarations of our 2 arborists, Gordon Mann and Carl Mellinger, and I think I went through that on the PowerPoint presentation. They said that essentially the city skewed the results of that by having a very low risk tolerance. You can, if your risk tolerance is nothing.
But to say you skewed without evidence, I mean, you could simply just say they skewed it, right? And you're saying that.
What?
But do you have evidence
Yes.
that the city skewed it?
I do. And that is in the declaration of Gordon Mann and the declaration of Carl Mellinger that are on file.
Okay.
And the city has those documents.
So again, it's he said, she said. We have 2 arborists. One saying they skewed it, and the other one saying the trees were, faulty. So it's not like we have like,
It's two issues. Number one, I hear your point on that, the battle of the experts thing, and the court weighed in and said that they believed one more over the other. The court was presented with all this information. And then the other issue is like, how do you define an emergency? Remember, I talked about how it's, what did I say here? And that has to be taken into consideration. Emergencies are limited to occurrences, not a condition. Occurrences, not a condition. And that's because this is an extraordinary thing. You're saying, I'm going to avoid CEQA because there is an emergency. And so this, our contention, and the court bought it, was that this was a condition of the trees that was long-standing, and that there wasn't a sudden, unexpected occurrence that caused these trees to need to be removed.
thank you. And that's my next question for staff. Can you please explain the emergency?
Yes, the emergency is the identified defects in the trees and also the target risks around those trees should they fail. In light of weather events, wind, rain, the rainy season was on schedule, right? It was early October, we decided to file the NOE and move forward with removing these trees. And under the definition of occurrence that appellant is putting forth, you couldn't remove a tree until it had fallen and done some damage, unfortunately.
And how soon were the trees removed after that declaration?
I'm sorry, after the arborist report or after the NOE?
The arborist report.
It was a matter of weeks.
Weeks. And the issue with the three trees being part of a grander scale, you're saying that the judge, that was his decision, not necessarily correct.
There were 122 Aleppo pines that were analyzed by the arborist in the September report, and these three were removed through the NOE in early October. And the judge and the order that council keeps referencing refers to 119 Aleppo pines.
Okay. And what does the appellate say about that?
What is the question one more time, sir?
The report said 122, and you reference 119.
There's definitely a little bit of discrepancy. The various reports have sort of deviated. It's somewhere between 119 to 125.
I know, and you
Yeah.
can see the position we're in. We're talking about three trees, and that deviation is rather large for us.
Yes, sir.
right?
So this is the report, the RPW report. So the RPW report did a assessment of 122 Aleppo pine trees. And so it did go ahead and list the trees by address here. And so we'd at least know that the three trees in question were part of the overall plan because they were listed by address. So despite the fact that there might be some, believe me, I've wondered about this too. Why is there 119 here and 122 here and 125 here? But I don't think that's sort of like an irrelevant issue because I do know that the three trees in question right here are listed on the report and they're part of the overall plan.
City Attorney?
Again, I would just remind the Planning Commission that all of this is beyond the scope of the limited issues that you're considering here tonight. But the arborist report did look at 122 Aleppo pine trees, and 3 of them were removed subject to this NOE, and the city is proceeding on environmental review on a project of 119 Aleppo pine trees. Actually, we've since discovered that one is not an Aleppo, it's a Italian stone pine. So 118 Aleppo pines and 1 Italian stone pine.
Understood. Okay. Any other questions for staff or the appellant? Seeing none, I now declare the hearing closed and the Planning Commission will now deliberate. This is the time for the commission to decide whether to affirm, reverse, or remand the director's environmental decision. What is the commission's pleasure?
there are obviously greater issues that have to be addressed with regard to the 119 trees. I am looking at this strictly from the way it's being presented to us tonight. There is I'm not an attorney, so I can just give my views on to what's been presented to us. This is a moot issue. 3 trees have been removed. We're being asked a specific question of denying the appeal and upholding community development for those 3 trees. The other issues that have been raised here tonight fall outside of the purview of this commission. We are also a commission that is not a messenger. We're not voting or we're not considering here whether or not we agree that these 119 trees should come down. We're being asked a specific question. And I really feel that we've got to step back here and say, what are we being asked to do? It's a very specific question. It's it's a yes or no given the moot issue of the trees. And again, to emphasize, we are not here to send messages. We are here to review plans, approve them, and make recommendations to the City Council. So, that's mine.
Mr. Mukatarian?
I will say, I did go over the RPW report. I did used to be a planner at the City of La Cañada Flint Ridge, and that's another Tree City USA, and I've seen far greater detailed reports for trees. I would say this particular report didn't go into specific enough detail for why those trees needed to be removed. But in the absence of another report that substantiates that they were healthy and the reasons, in the same manner that this was not very detailed, there's also not a lot of detail into whether these trees were healthy or not. Now, procedurally, it seems that what the director was responsible for, the procedure for going about this was upheld based on what the CEQA requirements are. And I think if that is what we're deliberating, that seems pretty straightforward. But I will say this report, I will agree with the appellant that it's not substantial enough to, whether those trees were warranted to come down or not. I will say this is not a great indicator for why those trees came down. But in the absence of another report that substantiates why they were healthy enough to stay, it's really difficult in a matter of days of receiving this information, because I got this information presented to me, and so did everyone else, within the last week. It's really difficult to make a determination, especially also we're not arborists, to be able to decide for an entire community what the correct answer is. But both, there's nothing else I can say with the evidence presented in front of me and the lack of evidence provided to whether these trees should have stayed. It's not one way or another. I can't go one way or another because I don't have enough evidence to be able to make a decision. But again, this commission is being asked to look at the procedural way, the procedure of how this was handled. And so with that, I think that this is, all we could do is look at the procedure as we've been instructed to do so.
Ms. Wick, I could jump in. We're not here to make rulings on trees tonight. We're not here to halt projects tonight. We have a very specific scope. But from a human standpoint, I get why you're upset. I live very close to Niagara. I've lived in Burbank my entire life. I grew up on Florence Street. Niagara was just a few streets over. I walked to school to Roosevelt every day. I get it. I will also tell you that I also feel like maybe our city doesn't do a great job of maintaining these trees. Maybe we don't have a large enough forestry staff. Maybe the trees are too big. I think we made some big mistakes on Magnolia. We planted the wrong kind of trees, but now they're beautiful, but now they have to come out because they're tearing up the infrastructure and the plumbing and the streets and the curbs and the gutters, and people are falling and suing. So I think mistakes are made. And I think the fact that we didn't have an alternative plan to water these trees during the drought. We told everyone, don't water. Well, what about the parkways? We should have had a plan of watering these trees. I'm not an arborist. I know nothing about trees, but something tells me that potentially that had something to do with some of these trees. So from a human standpoint, I get it, folks. I understand your passion. I understand neighborhoods as a real estate agent. I understand neighborhoods and why you want these trees. But we're not here tonight for that reason. We're only here for the specific scope. Did the director follow the right procedure? And there's a lot of pictures, and those aren't the right pictures, but you guys supplied the pictures, and we don't have enough evidence if these trees were healthy or not. Again, we're not here to be judge and jury, and we're getting all that information. And I hear you, but again, we just want to make sure, did the director follow the proper procedure? Everything else you guys are going to battle out in court. That's not what we're here to do tonight. So I'm going to uphold the director's decision because procedurally, I believe that he followed the right procedure.
I'll second that. Going off of what Chair Rosati said, I don't want to speak for all of my commissioners, but I would be hard pressed to say that we all love trees. We get it. We all live in Burbank. We all serve on this commission. Because we care about this city and we love this city, it's beautiful. But as my fellow commissioners have said, the scope of the project the scope of this is so small, and we need to stay focused on that. And again, you'd be hard pressed to find somebody on this commission who doesn't have a sympathetic ear to the trees. However, it would be so easy for us to get off on tangents. So thank you for staff and for the attorney to keeping this focused. We appreciate it tonight. And so I will second that motion.
All right, so I didn't make a motion. If somebody wants to make that motion.
And I want to thank you for all of the, I don't want to say emotion, but the feelings and the importance that you take in this matter. And I want to reiterate that I am not deciding whether or not these trees should come down. I'm reiterating the fact that we are presented with a specific proposal tonight that we have to address. But again, thank you for your passion.
Motion?
I move that the Planning Commission of the City of Burbank uphold the decision of the Community Development Director on project number 230005367, an appeal of the director's decision that emergency removal of the trees located at 113 North Niagara, 434 North Niagara, and 400 South Keystone are statutorily exempt from the California Environmental Quality Act pursuant to the California Code of Regulations, Title 14, Section 15269C pertaining to emergency projects.
We have a motion? We have a second. Any more discussion or deliberation? Seeing none, go ahead and poll us, please.
Chair Rosati,
Yes.
Vice Chair Wick,
Yes.
Commissioner Monaco,
Yes.
Commissioner Makatumian,
Yes.
and Commissioner Elric.
No.
Thank you. Motion passes. Thank you, everyone, for coming tonight. We're moving on to item number 2. Now is the time and place for the public hearing for project number 2300-03103, a proposed conditional use permit to allow for the incidental sale of beer, wine, and distilled spirits for the on-site consumption at the existing Chili John's restaurant at 2018 West Burbank Boulevard. Before we begin, do any planning board members have any legal, financial, or other conflict of interest regarding this hearing?
No.
No.
Have any planning board members had any, none, sorry. Have any planning board members had any communications, including written, oral, regarding this project?
No.
No.
No. Mr. Ramirez, have the notices by law been given?
Yes, they have.
And are there any written communications on this matter?
There was one correspondence, and that's been provided.
Yes.
I just want to state that a member of the public did contact me to ask me what time the meeting was regarding this issue.
Okay. Because they want a beer. Got it. Will the representative of the Community Development Department please introduce yourself and summarize the matter for us?
Sure. Hi, good evening. May I please have the presentation up on the screen? Thank you. Good evening, Chair Rosati and members of the Planning Commission. My name is Sarah Hernick, Assistant Planner with the City of Burbank Community Development Department. This evening, I'm presenting an application requesting approval of a conditional use permit for the property at 2018 West Burbank Boulevard, the site of the existing Chili John's restaurant. The representative of the applicant, Mr. Ariel Gutierrez, is here as well and will be available to respond to any questions after this presentation. The owners of the business, Steve and Claudine Hager, are also in attendance tonight. The project site is located at the southeast corner of North Keystone Street and West Burbank Boulevard, east of North Buena Vista Street. The project site is currently improved with one commercial building of approximately 2,700 square feet. This building is subdivided into 2 tenant spaces. One of the spaces is occupied by Chili John's restaurant, and the other space is currently vacant. The property is also improved with a surface parking lot with 9 spaces, which is accessed from the alley. Additionally, the applicant, who is also the owner of Chili John's, is the owner of the project site and all improvements. The project site is zoned C3, commercial general commercial business, and has a general plan designation of corridor commercial, which is a land use designation intended to provide neighborhood serving uses. Adjacent to the project site are commercial buildings to the north, east, and west along Burbank Boulevard, and single-family residential to the north and south of the commercial corridor, with R1 zoning directly to the south of the project site. The restaurant has been operational at 2018 West Burbank Boulevard since 1946, serving comfort food and specializing in chili. They provide both takeout and sit-down restaurant services. The business currently operates Sunday through Saturday from 11 a.m. to 7 p.m. The city has not received any noise or operational complaints from the community related to the business over the previous 5 years. Shown here are recent photos of Chili John's restaurant as seen from across Burbank Boulevard looking south. The applicant is requesting Planning Commission approval of a conditional use permit to allow for the on-site consumption of beer, wine, and distilled spirits in conjunction with the existing restaurant. Burbank Municipal Code Section 10-1-1116 requires restaurants with incidental sale and consumption of alcohol located within 150 feet of residentially zoned property to obtain Planning Commission approval of a CUP. The restaurant would operate as it is now, with the exception of expanded hours of operation, which I will detail shortly. Planning Commission approval of the conditional use permit would give the applicant the opportunity of applying for an alcohol license with the California Department of Alcoholic Beverage Control, also known as ABC. ABC is an agency of the government of the state of California charged with the regulation of alcoholic beverages. With approval of this conditional use permit, the applicant would be allowed to sell beer, wine, and distilled spirits, which would allow them to apply for either a Type 41 or Type 47 alcohol license with ABC. However, alcohol sales would be limited to on-site consumption. This is the existing site plan. Again, the property is improved with an existing commercial building and a surface parking lot. The area of the building occupied by Chili John's is highlighted in red. This is an image of the restaurant's existing floor plan. It would remain the same. No significant alterations are proposed to the interior of the building. A new outdoor patio area would be limited to 4 tables with outdoor seating on the sidewalk, adjacent to the tenant space and within the public right-of-way. The applicant is working with Public Works for approval of an encroachment permit for the patio seating area. As shown here, the sale of alcohol is proposed to be ancillary to the restaurant use, with approximately 12% of the floor area of the tenant space being devoted towards storage and sale of alcohol. As mentioned, the applicant is requesting to update the hours of operation. Included in this slide are the revised and requested hours of operation. The current hours are Sunday through Saturday from 11 a.m. to 7 p.m. The applicant is requesting to operate Sunday through Saturday from 11 a.m. to 12 a.m. with alcohol service ending at 11:30 p.m. inside. Alcohol sales in the outdoor dining area would be limited to no earlier than 11 a.m. and no later than 10 p.m. with alcohol service ending at 9:30. These proposed hours of alcohol sales have been included as conditions of approval. Burbank Municipal Code, Section 10-1-1116, requires certain operational standards that have been included in the conditions of approval. On the screen are those required standards that the business would be subject to in order to ensure compatibility with the surrounding uses. These include at least 65% of the gross sales revenue of the establishment must be from food sales. There is no dancing or live music at the establishment. Areas devoted to alcohol sales and storage must not be more than 15% of the floor area. And alcohol sales would only occur during the same business hours as food is sold. Additionally, alcoholic beverages may not leave the premises. No loitering or public drinking on private property signs shall be posted inside and outside of the facility, and the applicant will be required to provide employee training in alcoholic beverage compliance, crime prevention techniques, and the handling of violence. In addition to these, there are other operational conditions of approval included as part of Exhibit A, the resolution. As part of staff's review of a conditional use permit, the project was reviewed for consistency with the Burbank 2035 General Plan, the applicable zoning regulations, and the required conditional use permit findings per BMC Section 10-1-1936 as detailed in the staff report and attached resolution. As outlined in staff's report, it is staff's assessment that with the associated conditions of approval, the project complies with all applicable requirements. Therefore, staff recommends that the Planning Commission adopt the following resolution. A resolution of the Planning Commission of the City of Burbank approving a conditional use permit, project number 23-0003103, allowing for the incidental sale of beer, wine, and distilled spirits for on-site consumption at the existing Chili John's restaurant at 2018 West Burbank Boulevard, based on the findings of fact and subject to the project conditions of approval. This concludes staff's presentation. I'm available for any questions.
Thank you. We will now open the meeting up to hear from any persons who wish to speak on this matter. Each person may address the planning board for a maximum time of 3 minutes. For members of the public who wish to comment in person, please present a completed speaker card to the planning division staff. For members of the public who wish to comment by phone, 818-238-3335 is the number to address the planning board. Callers may be placed in the queue. All in-person comments will be received first. The phone lines are now open. If you can just turn down your speaker and TV and take the phone off speaker when you deliver your comment. Madam Clerk, do we have any callers?
We have one caller.
Okay, let me get the speaker for the in-person, Mr. Donahue.
Commissioners, Chair Rosati, David Donahue. I am I would say, pretty close resident to Chili John's. I'm probably a good, 300 yards away from it. Drive by it almost every day and have seen it as a great location. And I want to just say that I am super excited that they are applying for a CUP to be able to offer beer, wine, and distilled spirits. And I thought the one slide that excited me most was the outdoor dining. That is a portion of Burbank Boulevard that needs to have a little bit of development. If Chili John's is choosing to make the investment and the time and the staff and to train and to build the inventory, God bless them. Could be more excited about it. So thank you very much for bringing this up and having an opportunity to support Chili John's. Thank you.
Thank you. Can we get the, thank you. Can we get the person on the phone, please?
We have Jamie on the call.
Good evening.
Good evening. I am Jamie Keyser, CEO of the Burbank Chamber of Commerce, and calling in this evening to support the request for a conditional use permit for Chili John's. This will help their existing restaurant expand their services with outdoor seating and a delicious new menu, including the sales of beer, wine, and distilled spirits. Chili John's has been a valued member of the Chamber for many years and an icon in our community for 78 years. I love what David Donahue had to say, and I agree with that wholeheartedly. This process has been in the works for approximately 2 years, and last April, the Chamber came together with Mary Hamzoyan and Marissa Caldwell from the Economic Development Department to visit the restaurant and help with navigation and advice to get to the place we're at tonight. A big thank you to Mary and Marissa for their support. Economic recovery for small businesses and restaurants from the pandemic has been estimated at 5 years, and there is more work needed. With the outlay of cash to run a day-to-day operations of restaurants, it has a very low ROI. Inflation, minimum wage increase, and everything in between requires Chili John's to dig deep and reinvent themselves to make sure they are setting up their restaurant for success for another 78 years and beyond. This process has been challenging to say the least, but we finally got here. Please support this request for the conditional use permit, and I'd love to join you for a cold beer when their doors open. Thank you.
We have one more caller.
Great. Good evening.
We have Christopher on the call.
Hello, my name is Christopher Gerritsen. I've been a member of the Burbank community for the last 6 years, and I've had the pleasure of doing business directly with the Hagers for the past 3. In that time, I have come to know them as incredibly upstanding and responsible members of their community who have nothing but the best interests of their local community, their patrons, and their family in mind, which is why I am calling in today to support the conditional use permit that has been applied for. I do believe that the ability to sell wine and spirits at this location will help them take their business to the next level, which will only help raise up other local businesses in our area. I am very much looking forward to assisting them in any way that I can with this project and watching this business thrive. And I do think that this is only a good thing to have more local venues supporting our local restaurant, food service, and hospitality industry here in Burbank, which is my own personal mission statement. And I would also like to mention that the Hagers really were instrumental in bringing me into the Chamber of Commerce, encouraged me to join, and have really helped me build my own life and community here in the local Burbank area, which is why I think they are a perfect fit and possess the responsibility and business sense needed to responsibly operate a business that does serve alcohol in our community. Thank you very much.
Thank you. I now declare the public, is it any more callers? I now declare the public comment period closed. Would the applicant like to come up and make a few comments or a presentation?
I'm going to make it short, Commissioners. Thank you, and thank you for the opportunity. It's been a long time coming with this application, and we're finally here. And I appreciate the work with planning staff, and as you can see, the whole family is here. Been waiting anxiously to get this thing over with. So I really don't have, I mean, it's been said. They've been there for quite some time, 70 years, and it will continue to be run as a family establishment. It's an application for alcohol license. It's going to be scrutinized left and right from the state and to the city, so conditions will be imposed to make sure that any potential issues will be mitigated. So please support the project. I do want to point out that I know there was a restriction regarding live entertainment, and just to at least bring good music, ambient music for, for the patrons sitting there. I don't know if an acoustical music, you will entertain that as part of the condition, rather than amplified music. That's just the simple request that we're adding to this.
We'll take it under consideration when we deliberate.
Thank you. That's all I have.
Thank you.
You guys have any questions for the applicant?
We'll get to you. Thank you, bro. Thank you. I'm going to give the Community Development Department a minute to deal with that curveball. Are you ready?
Okay. Yes, I think that staff would generally be supportive of a alteration of an amendment to the conditions of approval, as long as it is non-amplified music.
I just can't hear you there.
Oh, I'm so sorry. I think that that staff would generally be supportive as long as it is non-amplified music. If you want to accommodate for that, we would recommend updating conditions of approval numbers 19 and 24 to allow for live music without amplification. And I guess the applicant would still have to comply with, would still have to operate within the noise restrictions as detailed in the Burbank Municipal Code and the general plan. But otherwise, it would just be altering conditions of approval 19 and 24.
Got it. Thank you. Does the commission have any questions for staff or the applicant? Mr. Howard.
The live music, where would you be playing it?
I will just defer to the applicant
I'm sorry
for this.
It's going to be for the applicant, right?
Yeah, sorry.
The applicant?
Hi, how you doing? Basically, we've heard from some of our restaurant customers that they would be interested in playing their acoustic instruments in the restaurant. I have one particular customer who would like to donate an upright piano so that he can play it in the tap room area. One of my staff members actually plays the saxophone, so he would be interested in setting up a chair and playing his saxophone for customers. Things of that nature, nothing very loud. We're not trying to start a rock concert or anything.
Okay.
Okay, thank you.
Any, Mr.
So indoors, sorry.
Indoors?
Absolutely indoors and absolutely acoustic music, not anything very loud.
Thank you.
On that note, will there be any speakers on the outdoor patio?
No.
Okay.
We do have a stereo system in the restaurant that we've been playing for our customers for many, many years, but it's never played very loud. It's just ambience music.
Thank you.
Ms. Wick?
Just a quick question for staff. Have there been any noise complaint calls to Chili John's in the past that you're aware of?
Thank you for your question, Commissioner. I reached out to the Burbank Police Department and inquired about the last 5 years of calls, and the city has not received any calls related to the operation of Chili John's in the last 5 years. There have been calls that, like nearby, like an altercation in the alley, but didn't involve the business.
Got it.
Oh, sorry, go ahead.
And just one more question for the applicant as well. As far as serving alcohol, is there some feedback? Or is that me? Oh, sorry, I thought I was hearing something. For the applicant, as far as serving alcohol, have you had experience serving alcohol, or could you speak to what type of training classes you're going to be offering your staff, or that type of thing? How would you mitigate potential issues serving alcohol, essentially? Speak to that.
Well, as far as serving alcohol, I do have personal experience as a bartender for many years. And my wife has also been a bartender previously before we owned the restaurant. And in California, we have a lot of really good laws and regulations in place that we're going to be following that are going to help us to mitigate any situations that may arise. And there is mandated training for the staff already by the state of California. And of course, we're going to be adhering to all laws and regulations regarding that.
Thank you.
Of course.
Mr. Monaco, you good?
All good.
All right, now declare the public hearing closed. What is the planning board's pleasure? Okay, so I'm going to say no on the acoustic music. Yeah, I know, I'm a bummer. And the reason why is because we sent out a public notice, right? And the public had no idea, there's homes in that general area across the alley, correct? And they didn't realize that there potentially was going to be music or acoustic music because the conditions of approval say no music. Not that I don't think it's appropriate, but I do think that if we were going to notice it, we should have noticed it. So this should have been brought up sooner than right now today. So everyone in the public gets all the information, and if they're good with it, great. If they're not, they'd be here tonight. That's my only reason for saying no on the acoustic music. If the fellow board members want to overrule me, I'm good with that too. Mr. Elwick, you got anything?
I'm fine with the acoustic music. They've got a speaker system that they've been using for years, and I'm okay with that.
I'd be okay with music as well. Maybe we can also put in a provision in the condition that within a certain amount of, a distance from the restaurant, that the music shouldn't be heard, or maybe 150 feet or something.
Chair, if I may, I think if we rely on the noise regulations, I think we'll get to the same situation, is that they'll have to comply with the noise regulations. So if those exceed the decibel levels required within a certain distance of the property, I think that may address Commissioner Mercatunian's concern.
Then in that case, I'd be okay with it.
Somebody make the motion.
This is a question now. How am I going to?
You're going to say as amended.
Oh, as amended, okay. I am making a motion that we approve a conditional use permit, project number 23-0003103, allowing for the incidental sale of beer, wine, and distilled spirits for an on-site consumption at the existing Chili John's restaurant at 2018 West Burbank Boulevard, based on the findings of fact and subject to the project conditions of approval as amended.
We have a motion.
I'll second.
We have a second. Any more deliberation or discussion?
As amended means with the acoustic music? Okay.
And then what was the clarification on the footage?
Oh, just that they would have to comply with the city's applicable noise regulations. And that would address issues from neighboring properties, so they have to comply.
Okay, because
with
we
those
did hear
requirements.
a couple things, right? We heard acoustic guitar, then we heard saxophone.
Yeah, but it would be basically non-amplified sound, and as far as complying with the noise requirement, that applies to all properties, so.
Okay.
They're in a specific zone, there's neighboring zones, they would have to be in compliance with the neighboring residential zones too.
Okay.
And Chair, I apologize if I may, Daniel via Community Development Department. I would also just ask that it also state that it be indoor. That way it's limited to inside the building.
Oh, that was my understanding. Okay, specifically indoors. Yeah, okay. Any more discussion?
Chair Rosati?
Yes. We have a motion and a second. We deliberated. Go ahead.
Chair Rosati?
No.
Vice Chair Wick?
Yes.
Commissioner Monaco?
Yes.
Commissioner Makatumian?
Yes.
And Commissioner Elric?
Yes.
Motion passes 4-1. Now is the time for, good luck to you guys. Good luck. Now is the time for reports from city staff. Are there any reports?
We do not have any new reports.
Okay. And now is the time for oral communications from the public. Any person speaking during this period may address the commission on any matter concerning city business. Each person may address the planning board for a maximum time of 3 minutes. For members of the public who wish to comment in person, please present a speaker card to the planning division. For members of the public that would like to call in, the number is 818-238-3335. Callers will be placed in a queue. comments will be received after the in-person calls. The phone lines are now open. Please bear with us as we take a couple of minutes to get the first few callers through. Please remember to lower your TV and take us off your speaker when delivering your comment. Mr. Donahue.
Good evening, Commissioners. David Donahue, resident, homeowner, business owner. During this general topic, I'm speaking to you as the current president of Vision Burbank. We recently had a meeting regarding Metro's plan for their bus rapid transit, or the BRT. On March 26th, on the City Council's forecasted calendar, they have a presentation from David Kriske about the cooperative agreement that will be between the city and with Metro, and we are worried that the city is going to deviate from the direction from City Council in 2022 for mixed flow. And this is the section of Olive Avenue between Buena Vista and the Olive Bridge. I think they're playing with the audio, so I appreciate that. So we are concerned that the current City Council will be recommending to staff to go back and to amend the cooperative agreement to include dedicated lanes. The members of Vision Burbank are adamantly opposed to this. The Chamber of Commerce is supporting our position that mixed flow should be the direction. And I'm bringing this to your attention that I would ask for you to agendize or have a report from David Kriske or his staff to you, because under the purview of this body is traffic. And I think that this would greatly affect the businesses and the residents that surround Olive Avenue because of the tremendous impact it would have, as proven with the city of Culver City, which that city council voted 3-2 to remove their dedicated lanes because of the impact that it had to businesses and residents. So if possible, if permitted, I would ask for an agendized item or at least a report to your body about the potential impacts of having or just the cooperative agreement that the city staff is recommending to council so that your advice and perspective could be added. Thank you.
Thank you. Do we have anyone on the phone?
No speakers.
Great. I now declare the public comment period closed. Now is the time for the approval of minutes from January 8th, 2024. Do we have a motion for that?
I move to approve the minutes.
Second.
We have a second. Any discussion?
Chair Rosati?
Yes.
Vice Chair Wick?
Yes.
Commissioner Monaco? Yes. Commissioner Makatumian?
Yes.
And Commissioner Elric?
Yes.
Great. Now is the time to introduce additional agenda items. Planning board members may introduce new items for discussion, but no action may take place except to place them on a future agenda. What about that BRT? Is that in our purview? Are we going to see that?
Well, not in the sense of what's being considered by what Mr. Kriske would be presenting to the council. If you want an update regarding the outcome of whatever's presented to council and their decision, I can inquire about having him give us a summary of what's transpired.
But not before the fact?
I don't know what the report is going to say or what's going to be told to council. So it's speculative at this point until no one's made a decision. Council hasn't taken action in a public hearing or meeting. So once I know what their direction is going to be, then we can report back.
Is that part of traffic where we would come in or no?
Well, no, if it was a project where you were reviewing a full project with the environmental, that has a section on transportation and potentially roadway geometry and other issues, but there's no project that's being brought forth for your review and approval at this time. This is a cooperative agreement between the council, the city, and Metro. And I think my understanding of it is primarily it's related to the actual review of plans that are being proposed for the actual physical improvements under the BRT, which was previously reviewed and there was an environmental document prepared. We can always report back subsequent to that meeting on any actions that they've taken, and I'm pretty sure Mr. Kriske would be more than willing to come and give you an update.
Okay.
Do I still have any agenda items out there?
The ones that you had were, I think when we last spoke and presented, were going to be included as part of the Rancho Burbank specific plan.
Right. Okay.
Okay, now is the time for city planner comments. Are there any comments from the planner?
No, thank you all for, tonight's meeting. I think you really were able to kind of get through a lot of information, and really appreciated the way you all handled yourselves and conducted the meeting. So I know there's a lot of emotion on both sides of the equation here, and it's very unique, this P-node process, and they kind of this is the first one that I've interacted with in my couple years here. So no, thank you for just your deliberation, your attention to detail, and also just the empathy I think you all showed for all those that spoke tonight. So thank you.
Okay, we will now adjourn the planning board meeting on Monday, February 26, 2024 at 6 p.m. This meeting will be held in person in the city chambers at 275 East Olive Avenue. The public is invited to attend the meeting in person or view the meeting online. The public will be able to provide public comment in the following ways: in person or e-comment at www.burbankca.gov/ecomments, or by calling in directly to the board 818-238-3335. Thank you all for your participation tonight.